Now, I've got the very great pleasure to introduce two of my colleagues in the commercial property law area of practice on Green's list. Both of these colleagues have the extra distinction of being authors of legal texts. Both of them are also barristers with expertise in the property law area, and that's what they're going to address you on this morning. David Bailey, first to my left, has had 13 years' experience at the commercial bar, practising in the broad commercial areas, but including property law. His previous experience was at the top end of the financial and international trade legal world, and he was also a company director, and he's used to advising company directors on their duties and corporate governance. His expertise in the international trade area led him to his long and distinguished service to the legal profession on the Australian Law Council and the international. He was the inaugural chair of the International Law Section, and he also led him into the Attorney General's Working Committee on commercial arbitration and the UNCITRAL model law. Now, that law is now the basis not only of international commercial arbitration in Australia, but even domestic arbitration in Victoria. He was a founding member of ACICA, that's the Australian Centre for International Commercial Arbitration, and he was on its board for 25 years. He's now a commercial barrister with that broad range of experience in commercial law, and he's also the senior editor of Civil Procedure Victoria, which people of my generation know better as Williams. His broad commercial and property law practice at the bar is such that he appears in all courts, and he also appears in arbitrations and has recent experience of international commercial arbitration on a major scale. This morning he'll address you for half an hour on the pitfalls of property transactions, and he'll use his PowerPoint, which I'm probably mucking up, to focus and condense. I think it's about a 37-page paper which he's written, which is a real resource on the areas of easements and restrictive covenants. As soon as I scanned through it, I saved it an electronic copy in my folders on easements and restrictive covenants. What he's going to do is direct that to the pitfalls in the areas that he's written on. James McKay is a very busy young general commercial barrister with an emphasis also on real property. He also has cases in contract equity and trade practice disputes, and he's developed an excellent commercial practice in his under 5 years at the bar through his very hard work. 2 years with his father in a suburban legal practice taught him some of the qualities that a barrister should have from a solicitor's point of view, gave him a grounding and helpful attitude that some of us at the bar didn't have. But it's also kindled his interest in property transactions. Now, that property emphasis and expertise has and will continue to be developed through his authorship of the CCH Victorian Conveyancing Law and Practice Service under the guidance of His Honour Justice Croft. I know the benefit of an association with Justice Croft because I had the very good fortune to share chambers with him for some years. Perhaps that's why I had a more flourishing property law practice in those days. But James is the one who's got the benefit of Dr. Croft as he then was in my day, and Justice Croft as he now is, the expertise that he can assimilate from training under Justice Croft. When you look at James' profile on the bar, his cases of interest show 27 serious property law cases and 31 commercial and equity cases in the short 5 years since I first met him when he read on my floor in this building. The breadth of his expertise is quite considerable. You'll see cases not only is a majority on landlord and tenant, but there's easements, restrictive covenants, a joint venture property development, off-the-plan purchases, which we'll talk to you about today, and contracts, mortgages and injunctions. And getting an injunction or defending an injunction really concentrates the mind very, very quickly. And you've got to know your stuff. There's no better way of understanding the law than to argue a case applying the principles to the facts of your situation, and he's had 5 years' experience doing that in a very detailed and professional way. He also has the personal recommendation of an old solicitor friend of mine whose judgment I respect very much, but because he's on leave at the moment, I couldn't ask whether that had anything to do with friendship with his father. James will present his paper focused on the particular pitfall in the area of off-the-plan sales where a purchaser finds what has been built is far less than what they were led to believe by the information that was available at the time they signed the contract. It's described as a pitfall, but I've read that paper and it looks to me more like a minefield. James will lead you through that first. I'd like you to welcome him, please.
Thanks very much for the warm welcome, John. Now, those of you that have heard me speak before will realise I've got quite an interest in the field of off-the-plan sales, and it's an interest that's not so much necessarily born out of any academic insight into the field, but more of necessity. It's a field in which constantly I'm getting calls from solicitors with various problems, particularly from the perspective of purchasers wanting to get out of contracts when they can't settle. It's an area that's likely, in my opinion and my experience, to lead more commonly than ordinary conveyancing transactions to disputation, because the transactions take place obviously over some time. Quite often it might be years whilst the developer takes its time to get the plan registered and to create the title that's to be conveyed. And we also have building obligations under these contracts that take some time to implement. So it's the kind of thing where, as we all know, we get to the end and the purchaser can't settle, or we have a developer that's struggling, and financial issues become something that threatens the ability of the parties to complete and observe their contractual obligations. Also, legally, it's obviously a complex issue. There's legislation that applies, particularly under the Sale of Land Act, that is often technical and complex, and it has absolute results in terms of the fertility of the transaction, if you like, in the sense that if you make out one of these arguments or loopholes under Section 9AA, for example, then it gives an absolute right of avoidance of the contract up until the plan is registered. So other fields of law perhaps that involve common law principles like repudiation, it's a little bit grey, and the court has a discretion perhaps as to how far it goes or how it construes the facts in terms of deciding whether an avoidance right is made out, whereas in the field of off-the-plan sales, quite often a mistake can be fatal, and absolutely fatal in the sense that there's no discretion on the part of the court to essentially forgive the error and allow the transaction to proceed. Now, this particular topic I'm speaking about today really carries on from a topic I addressed last September in one of the breakfast briefings, which was a paper to do with the doctrine in flight and booth, which ironically is a case that was decided in 1834, but nonetheless, with off-the-plan sales coming to the fore in the modern economy, it's something that's having a bit of a resurgence for reasons I'll go into in the course of the paper. But specifically what we're dealing with here today is an issue that's arisen concerning the measurements and the way these properties are described in many, if not most, contracts of sale, that in my opinion leads to a significant difficulty or contradiction, if you like, that causes many of these properties to be overstated or overestimated in their size by the vendor developers, leading of course to a situation where we might have a difference in size that exceeds 5%, being that usually accepted rule that's often embodied in contracts, and also the common law boundary, if you like, where it gets to the point where the authorities show that if there is that 5% difference, you may be able to get out of the contract as purchaser. So I'll come to an explanation of what it is we're dealing with here. Before I do so, there's some context that's necessary just to understand the background and to give you some idea of what it is I'll be speaking about. Now, just some basics, of course. The difference between an off-the-plan transaction and a standard conveyance is self-evident but important in the context of this paper, and it is that it's not just to convey a pre-existing lot where the obligation is straightforward. There's also a necessity of carrying out steps to create a new title that is then conveyed in the future. Combined with that, we then have building obligations that so often accompany that obligation to convey title, and that's particularly the case in any high-density block of residential apartments. Now, therefore, there's a linkage, if you like, between the obligation to convey title, which is the traditional obligation of a vendor, and the obligation to procure the building, which is something that's perhaps slightly newer in this context. And that linkage is absolute, or at least very important in the field of higher density apartment blocks, because as we all know, under the modern subdivision regulations, it's quite rare to have each individual apartment given some kind of dimension so that you can work out from measurements alone and from datums and surveyors' markings where the relevant boundaries are. Instead, the boundaries are actually defined by the structures themselves. So you'll have a boundary lying maybe part of the way through a wall or a ceiling or a slab, something of that nature. And so there's this linkage between title and the nature of the conveyance as commonly understood and the obligation to build, in the sense that the title is itself defined by the building that's constructed by the developer. And that, of course, highlights the problem with plans of subdivision in the modern era with respect to these higher density apartments. The issue is that we're not told in that fundamental document that gives us all the information to tell us what we're actually buying. We're not told how big the apartment is that we're buying in that document in the vast majority of cases. So it's ironic that the thing that defines the title lacks the very definition that would give us perhaps the most important information as purchaser that we'd be seeking, which is simply what is the area of what it is that we're purchasing. Now, lawyers respond to this issue in a number of ways. I've seen some contracts that do not contain any measurements at all. We might have some fairly sparse specifications or some outline of a floor plan of what the building might look like when it's constructed, a very generalised obligation to procure construction of the building, but no measurements in the contract whatsoever. You might think by the end of this paper that could be a satisfactory way to handle things, because just to avoid the issue of trying to define the size of the property could be worthwhile. But the problem I have with that approach is that it creates issues of contractual certainty. To have a title that's not defined in its area in any way is probably not ideal from that perspective, because it's arguable then that the contract lacks content and is therefore arguably void at common law. It's also not so much good from a marketing perspective as well to have something that doesn't have any assurance as to size in the documents. That being the case, what more often than not happens in my experience is there's town planning drawings that were usually used by the developer at the VCAT stage of approval that are then incorporated into the contract as an annexure, which are then picked up by special conditions in the contract that refer to the town planning drawings and link the obligation to construct with the content of the town planning drawings, so that in essence it says we, the developer, shall procure construction of a building that accords with annexure A or whatever it is, and that will be a reference to the town planning drawings. Now that, in my experience, is often the point where the dimensions are introduced. We have some numbers, for example, in the middle of the living room that signify that the apartment is whatever it is, 40 square metres internal, it'll have 40 square metres inside. If there's a balcony, it'll have the same notation in the town planning drawings. Or it might have a separate table that gives you the area of each of the apartments. But whichever way it's presented, the issue is the same. The size is now introduced into the contract in a document that's separate from the document that defines the title, being the plan of subdivision. So we have this mismatch between the two fundamental components of the contract that, in the case I'm about to outline to you, created the difficulty that led to the successful rescission of the contract. And the importance of all of this is that the case I'm about to take you to and the problem discussed therein, in my submission to you, will not be an isolated problem. It's The argument that was essentially used here successfully is an argument I've since used in mediations to affect settlements. It's an argument where people are calling me on the phone and saying, I've read the case, I've got the same problem, this, that and the other, and are really outlining similar nightmare stories as the developer went through in this case. The reason for that is that there's some kind of pattern, it seems, whereby architects, who are the ones that draw up these town planning drawings, adopting a methodology of measurement that differs often quite radically from the method that's used by the surveyors when they draw up the plan of subdivision, when they define the boundaries in the title. And what I mean is this: there's guidelines specified by the Property Council of Australia that are used by architects virtually across the board and that take as the boundary of an apartment, for the purposes of carrying out the measurement, the external parts of the wall, so that we have all the skin, the structure that's taken into account and measured as part of the private lot when the measurements are carried out. So that's then incorporated into the contract and into the measurements that we have in the contractual documents. And the question then becomes, do we have an issue if the plan of subdivision, on the other hand, does not, as part of the title, include all of the walls and exterior? What if, as is common, the title boundary is the interior face of the apartment? So we have that mismatch. What's being actually conveyed to the purchaser under the contract starts at the interior wall, just like here we're looking at these interior walls, but according to the town planning drawings, the measurements that have taken place there encompass a whole host of other things that are outside that interior face that are not part of what is to be conveyed to the purchaser under the contract. And that's the essence of the problem that we encountered in this case. Now, the decision is Birch and Robek Australia Proprietary Limited. It's reported on the internet in the Australian Legal Information Database at 2014 VCC 68. It was a decision of Judge Kennedy that was handed down in late February of this year. Now, the facts were these. Birch was the plaintiff. She was a 24-year-old flight attendant. She lived at home in her early 20s and saved up a deposit of $40,000 to buy her first home, which she intended to be an off-the-plan property to claim stamp duty exemptions. One Sunday, she inspects a particular block of apartments known as the Lido Apartments in Hampton, and obviously some effective selling took place on that day because she ended up leaving there with a signed contract. Most unwisely, it might be that she didn't have her parents there or someone to assist her, but she's just gone straight ahead without any sort of further research and executed the contract that day, and has not realised that the cooling off period was only for 3 days. She believed it was 14 days for some reason. I'm not sure how that idea got into her head. But the point is, by the time she got the contract and realised that the cooling off period was limited in that way, she was locked in. And we then have all these problems that are outlined in the rest of the paper. Now, it's significant that when Birch was dealing with the selling agent at the display suite, she advised that agent that, according to her understanding, it was necessary that the internal area of the apartment was 40 square metres in size. And she'd received that information from her boyfriend, who was a mortgage broker working at the ANZ Bank. So it wasn't just some sort of hearsay, that she seemed to have a good ground for that information and made sure she outlined that to the selling agent. The selling agent, in consequence of that, produces one of the brochures that applied to a certain category of apartments that was in fact 40 square metres in internal space, and it also had a balcony of 8 metres square. Now, the dimensions were given to Birch in a brochure, a sort of typical glossy brochure that would accompany these kind of off-the-plan sales in most cases. You have the the sort of plan, if you like, the floor plan of the apartment, and that floor plan was in turn taken from town planning drawings, which were included in the contract as an annexure in the way I described before. The town planning drawings in the contract also had dimensions both inside of the floor plan of the apartment as depicted, and also in a separate table. So we have the same set of measurements being essentially given to her 3 times, and all of them matching. And she said that, or said in her evidence, that she specifically took the contract home and checked that the measurements in the brochure matched the table and matched the depictions in the floor plan in the contract. So in her mind, she's getting these very clear representations as to size from all of the documents that she was provided with. Now, all progressed well for some time. As you'd be aware, there'd be a significant lapse between the sale and then the eventual settlement. Settlement years, and then her mortgagee asked to inspect the property, or at least its valuer to inspect the property for the purposes of obtaining and formalising the 80% finance, which she'd had a sort of conditional approval on at that point. She received a nasty shock when the mortgagee's valuer went into the property about a month before settlement and came out saying that the internal area as measured by him was 32 metres squared and not 40 metres squared. Now, after some unfortunate discussions, you might say, with the developer, where they were most hesitant to allow her to come in with surveyors to get the thing checked out properly, she did manage to secure access, both for herself, her lawyer and her surveyor, to measure everything up. And the measurements that were ultimately taken and then adduced into evidence at the trial, I'll give you in a moment. But safe to say there were a number of different methods that were used and ultimately argued in the county court as to how to measure the thing properly. 4 in total were discussed, but all of them, save for one, being the Property Council guidelines, of course, meant that there was over a 10% difference between what was represented in both the brochure and the town planning drawings and what was actually there in reality, what had been constructed by the developer. So that being the case, without issuing the 14-day rescission notice, which, by the way, was a requirement under the contract, she purported to rescind immediately based on the rule in Flight and Booth or a fundamental breach. The lawyers for the developer took the usual course and the very next day issued the 14-day notice. Obviously, they probably could have accepted her repudiation, or her alleged repudiation, but they chose to go down the safe path and use the 14-day notice procedure. There was the usual machinations about release of the deposit, and then that ended up staying in trust, and the thing wound its way to the county court with us claiming the deposit and the vendor counterclaiming essentially for a declaration that had validly forfeited the deposit and also for damages on the eventual resale. And the resale itself is significant. I mean, it shows you the danger of being a purchaser in these scenarios. The resale value was $58,000 less than the initial sale, and we're talking bottom end of the market here. She purchased for $359,000. So the drop of $58,000 on the resale, in our mind, was something that we were making an issue of at trial. I mean, it just shows you that the ability of somebody to sell something that does not exist in physical reality at the time, based on these measurements that are given, puts a purchaser in an especially vulnerable situation, to the point where somebody that could walk in with their own tape measure and see the place decided to pay $60,000 less, even though the market had gone up since that time. But that's an aside. I'll come back to what happened next. Now, the initial statement of claim as it was framed focused on the internal, or the discrepancy, if you like, between the usable floor space, so that measurement incorporated everything from the interior face of the walls and did not include any partitioning walls. So it was literally just the floor space that you could walk on and occupy, the airspace essentially. And I came into the case at that point and said, well, I think, no, that's not the right way to do it. The correct measure, if you like, is the difference between the on-title space, which we then had the surveyor go and measure, and the space that existed or was represented in the contract. And I'll just give you the measurements generally that we ended up taking once the surveyor had been back to look at the thing again. Now, you'll recall I mentioned the Property Council of Australia guidelines. So this is the one that was most favourable, obviously, to the developer, which was no doubt why it's utilised generally and why it was relied upon so heavily in this case. If that method was used, then the total area was 47.5 metres squared. So the representation in the contract was 48.5. So if you use the PCA guidelines, the thing was basically as big as it was supposed to be. But the other 3 methods was where we encountered a difficulty. If you used the titled area methodology, so measured that which she was to receive under the contract at law, i.e. that was contained in the relevant lot on the plan, then the thing shrinks to 42.6 metres squared. Now, the measure I outlined to you before, usable floor space, that was only 40 metres squared, or 40.4 metres. And if you included the petitioning walls, then it became 41.8 metres squared. So the percentages there are PCA guidelines, only 2% less, but titled area 12.17% less. And then internal area, including the petitioning walls, 13.82%, and then usable floor space, 16.71%. Now, the vendors adduced evidence to say that always they'd intended to give their measurements in accordance with the PCA guidelines. The evidence was both from the head architect at the firm that designed the town planning drawings, and he said that he'd instructed his underling essentially to draw the documents using that methodology, and that was accepted as being truthful evidence. There was also general evidence given by an expert surveyor who had expertise in doing large off-the-plan developments, whereby he said that these PCA guidelines are an industry standard across the entire country and something he's always used and never known anything else to be commonly used unless there's some special situation. Now, just to give you a bit more detail on how the PCA guidelines work, in a case, just to pretend that this room is something we're trying to measure using that guideline, if you like, to the extent that there's this title, pretend it's all contained in one enclosed title, one parcel of land. If there's a wall that adjoins another title that's on a separate subdivision, then in that circumstance you take the boundary as being the external face of the wall. So in this case it would be the outside skin of the walls that we see around us. In the case of adjoining tenancies, so in the case of these apartments, if there's two apartments next to each other, in that circumstance the PCA guidelines say it should be the midpoint of the wall. And in circumstances where it's common property outside, but then inside the private lot, we have the external face again. So in this particular apartment, the upshot of all that was that in most cases, there was either a lot outside, like a separate lot in a different subdivision, or common property that surrounded the particular apartment. So that meant that the boundary was, for PCA purposes, treated as being the external skin of the building, and the walls were quite thick. And we're dealing here with an apartment, as I said, that's really at the bottom end of the market. Even as represented, it was a particularly small apartment. So believe it or not, this wall space that I'm referring to ended up making that massive difference in the overall area calculation. And I should add as well, this is not a case where the developer has really accordioned the building in some way so as to reduce the size in terms of construction techniques. There may have been a small degree of that, but that wasn't any significant factor in all of this. There ended up being very substantial evidence that was adduced at the trial to show that the building was essentially built in accordance with the plans and the PCA guidelines. So it's not a case where all these factors I'm outlining to you were not really that relevant to the developer, just shrunk the building. The developer had, in fact, built the building in accordance with the PCA guidelines, at least substantially. So the upshot is the external walls were a massive part of it. It changed the measurement by that massive 12%. Now, the argument put by the vendor developers was this. They were saying that flight and booth depends on, or is only activated when the purchaser who tries to rely on that doctrine acts prudently and vigilantly. And he got that from a case from 1836, which usually is a bad sign for any argument if you have to go that far back in time to find favourable material, but that's what happened in this case. Saying essentially that there was a duty of care that was breached here by Birch in her not making satisfactory inquiries to ascertain what these measurements meant that were given to her in the town planning drawings. And that submission was amplified by pointing to special conditions that specifically said to her, you've got to make your own inquiries, there's different methods of measurement, all of those things. And it was said that if she'd had done even the most basic check by either calling up the developer or calling the architect, whose number was actually included on the town planning drawings, then what she would have been told is that, no, there's a difference here between what you're getting on title and what's actually measured in these drawings. Now, the problem for the developer, of course, was that there's nothing actually in the contract at all, either on the town planning drawings or anywhere else, that said that, or that explained that fact in any clear way. So it was not made clear at all there was that discrepancy between what was to be sold and what was being measured in the contract drawings. And in fact, it didn't even have any reference to the PCA guidelines. It never said at the bottom, warning Property Council measurements being adopted here. Nothing that would give anyone that indication, let alone somebody who gave evidence that she had no real sophistication in this field, she had no experience in law, anything like that. Her only qualification was as an actor, and then she was a flight attendant at the time. So somebody that wouldn't be on the lookout for this kind of issue lurking in the papers, if you like. So what we were saying on behalf of Birch was that Flight and Booth, I mean, I said before, ridiculed going back to the old cases to mount an argument, and I said that this Flight and Booth case had a modern rebirth. And the reason for that is because these off-the-plan apartments are not constructed at the time when the contract is formed, the courts are very much resorting back to this old rule and giving it new life by saying that there's essentially an extra burden on the developer to ensure that that which they actually build and want to convey to the purchaser accords substantially with its description in the contractual documents. The principle's been, if you like, eroded for many years now in terms of normal suburban conveyances, because there's clauses in those contracts that say you should go and essentially measure the thing yourself, and always there's that right there. I mean, any purchaser that buys a conveyance or a normal suburban block can go and carry out their own measurements because the thing exists in reality. As I said, it's not the case with an off-the-plan transaction, so Flight and Booth is something that's becoming resurgent all across the country, where you see it cited almost exclusively in the context of off-the-plan sales. And so we said here that the whole gist of the case was that there was a necessary linkage between the measurements that had been given to her in the contract, the town planning drawings, and the lot that was to be actually conveyed to her. We sought to do that by going through the contract carefully and explaining how that linkage arose. And it was done just by pointing out the basic features of the contract, which either expressly or by a sort of necessary implication linked the two, so that we were to get the measurements of what she was buying from the town planning drawings that were included in the contract. And remember again that the plan of subdivision itself had no measurements that allowed her to work out the area. So the gist of the submission the whole way through was that the absence of measurements in that document meant we were to go back to the town planning drawings and use those measurements to define that which she was to receive under the contract. Now, a recurrent theme throughout the argument about the special conditions was that the property was defined by reference to the plan of subdivision. So that's, of course, the usual way these things work. You'll have your particulars saying that it's Lot 2 on proposed plan of subdivision X, and then that will refer you to the plan. And that was then defined in the definitions of the special conditions as the property. So the property throughout the whole thing, capitalised if you like, was the property in the plan. The problem for the developer was that there was then all these special conditions that implied that the property, as so defined, had to have some kind of area in order for the contract to work. So, for example, this is one special condition. It says, property as shown on the plan of subdivision and the property as shown on the plan of subdivision when registered, if there's a difference, not greater than 5% variation or discrepancy in area. So the reference to that discrepancy in area or that variation implied that there had to be some kind of area given for the property being sold. And so the only way that could be is if the property dimensions were defined by what was in the town planning drawings. And so it went on. There was another condition that said the purchaser must rely on its own inquiries in relation to the areas and dimensions of the property, having regard to the architectural plans. So areas and dimensions, if there's no areas and dimensions in the actual plan of subdivision itself, it's actually telling you you've got to get those areas and dimensions from the town planning drawings. So the submission ultimately became this, that this was not just an obligation to convey a title without any accompanying obligation as to size. The whole way that the contract was structured was to have two central obligations. One was to create and convey the title that matched the description in the particulars, Lot 2 on PS, whatever it was. But also, because of the way the special conditions were structured, it had to have either the size or the approximate size that was set out in the town planning drawings, that being, or that following necessarily from the way the conditions were crafted. And that was ultimately accepted as being a fatal error in the contract. What Judge Kennedy said in the end was that there was just an obligation to convey something that was not just lot 2, but lot 2 of a particular size. And by giving the measurements in this way, and by including all this wall space and duct space or whatever it was that was in fact not part of what she was getting under the contract, that was a fatal flaw. Now, it was an interesting outcome in a sense because, as the developer said under cross-examination, he essentially accused the whole thing of being smoke and mirrors, if you like, because he was saying, well, it's really just the way you're using the measurements that is the significant thing here. There's nothing of substance in what you're saying because she still gets the benefit of all of the walls and ceilings around her, and so there's nothing improper about measuring the thing in that way in the architectural plans. And the response, both from me and the court obviously, was, well, it's not good enough because she's only buying the airspace starting at the inside of the walls. So to measure the thing and tell her she's getting something that's in fact bigger than that misleads her because she thinks that the property starting at the interior face of the walls is what she's buying and that it actually is the size as represented. So essentially it does shrink the apartment in substance because that reduction in size follows from all of this in the sense that the real, what she's thinking in her mind she's getting starts at that internal wall space and she thinks it has the dimensions given here when in fact it's representing something entirely different. So it mattered in substance and that was ultimately the finding. Now just to, sorry. Time's up. Yep. So I'll just say one more thing. I mean, the lesson to be learnt here is fairly obvious. You should note that this is going on. You should include some kind of special condition that specifically says that there might be a discrepancy between what's measured in the town planning drawings and what is to be conveyed under the contract. You should make that inquiry and see whether the PCA guidelines are being used to measure the thing in the town planning drawings. And once that is ascertained as being the case, you can then take an appropriate response to inform the purchaser of that fact. Thank you.